Thank you very much, Madam Professor, for the introduction. And first, let me thank you, thank the Mádl Institute for inviting us to this most prestigious presentation. We will be co-criminals, so to say, in this presentation with Assistant Professor Bence Benjamin, because we have also co-authored the book about this topic. So we will talk about the protection of the financial interests of the European Union, and we will talk about anti-money laundering activities. We have three important goals for this presentation. We will talk about the tools, the instruments that we have available to protect the financial interests of the EU and to combat money laundering, and we will discuss member state and EU level solutions, and the third is the situation in Hungary. So what are the links between these two topics? In the protection of the financial interest of the European Union, we do not only include fraud, but also other crimes. The PIF directive quite clearly identifies money laundering, for example, but it can also be put into a broader context, because it's not only important for the European Union to combat money laundering, because money laundering has a transnational nature, so international cooperation is highly important in this domain. Many previous speakers already mentioned the need to meet EU and international requirements when it comes to national legislation. But in money laundering, I must add one more component that has not been mentioned up to this point, because so far we have been talking about hard law. However, money laundering is a domain where soft law must also be mentioned, because there are many recommendation level documents exerting a major impact on the way nation states develop their own rules. Indirectly, a European Union document may make references to FAT, for example, action groups having formulated 40 recommendations, and this is something that I feel the need to mention, because we have not yet heard of this trend in the context of this conference. So after these introductory words, allow me to pass the word to the floor to my colleague. So I agreed with the professor that first I will talk about the protection of the European Union's financial interests, and after that we will talk about combating money laundering. I feel the need to say thank you to Assistant Professor Murai for having drawn your attention to the importance of protecting the EU's needs and interests, because it's no exaggeration to say that the EU's financial interests must be protected by proper legislation. So why do we need to combat acts violating the financial interests of the European Union? There are economic as well as political reasons for this, and you will not be surprised when I say that such acts cause significant financial losses on the expenditure as well as the revenue side of the European Union. Although the official statistics of the European Commission estimate the loss to be 1 or 2% of the total budget, but less optimistic estimations have concluded that it may be as much as 10% being lost. So some estimations argue that 1/5 of the EU's budget goes down the drain, so to say, through various illegal channels. So it is quite some sum for the EU to pay attention to. But there are also some political reasons, because these distort the competition in the internal market, they threaten the implementation of certain EU policies, and they also threaten integration processes in an indirect manner. And they also shake citizens' confidence in the functioning of the European Union. As a result of all this, the European Union have understood early on that they need to create a coherent, effective, and uniform system system to combat these crimes. In what way this might happen? Well, there are several answers to that question. This is just one of the classifications that are possible, that is possible. On the one hand, we can speak of criminal law instruments because obviously these are crimes that should be combated by the Criminal Code. But the EU may also be mandated to request harmonization of the legislation among the various member states. But it must also be mentioned that there is a criminal cooperation among the various member states in the form of horizontal cooperation, in the form of new forms of cooperation, and there are also supranational EU institutions dedicated to this purpose. We must also mention that there are non-criminal law measures available to us in our ambitions. Checking that the budget is properly implemented, for example, is one of them. And on the other hand, preventive measures do play a very important role also in this regard. In the framework of my presentation, I will only focus on the criminal law instruments. Here we can say that the Lisbon Agreement provides the EU with very strong measures in terms of legal approximation, supranational approximation, as well as by the setting up of a European Prosecution Office. This obviously does not mean that everything started with the Lisbon Treaty, because already before that legal instruments were adopted combating such crimes. And these were the agreements on the protection of financial interests and their supplementary protocols or additional protocols. However, after the Lisbon Treaty, we found that there was a new impetus gained. In 2017, the EU adopted two important sources of law, Directive 1371, and a council regulation was also adopted in the same year, and the two are very closely interrelated. In our book, in our study, and also in this presentation, we are only focusing on the most important provisions of the PIF directive. The directive rests on two pillars. One is the identification of the acts that are violating the financial interests and that therefore are punishable. And the other pillar concerns the sanctions. It gives guidance as well as establishes mandatory requirements for the member states. Among the criminal acts, offenses, the directive does not only regulate fraud in the restricted sense of the word, but also other criminal offenses that might violate the financial interests of the EU. For example, money laundering, corruption in its passive and active form, as well as embezzlement. Fraud is split into two parts in the directive, fraud on the revenue side and fraud on the expenditure side, and also below that there are two further subcategories. I think that the VAT fraud is worth another little remark, because it is only covered by a compromise solution, and it only covers VAT fraud in a that are of a transnational nature and that cause at least a loss of 10 million euros. In terms of sanctions, the directive identifies thresholds below 10,000 euros. The member states have liberty to decide whether they wish to use criminal measures or only administration measures. So it is not mandatory to use the criminal code. However, above the threshold of 10,000 euros, it is mandatory to use the criminal measures and even imprisonment. And above 100 euros, the legal consequence should be at least 4 years of imprisonment. And after this, I would like to refer to the specialities of the national legislation. In this respect, we have identified a particular criterion for classification. There are some countries in which the national budget and the EU budget are both subjected to the same measures. In other countries, they are treated separately, and two separate crimes have been identified for the protection of the national budget and another one for the EU budget. And in some other countries still, budget fraud is not regulated in the criminal code, but in a separate piece of legislation. And there is one particular country where in the absence of EU accession, it is only the national budget that is protected. And very briefly, I want to touch on the Hungarian regulation in this respect, because the budget fraud regulation of the Hungarian Criminal Code clearly indicates some specificities. The Hungarian Criminal Code treats budgetary fraud in Chapter 39, and there are a total of 4 different cases included here, and the budgetary fraud case is what deserves detailed attention. Budgetary fraud goes back to 2012 because already in the criminal code before the present one, there was an amendment made to the regulation. And the goal then was that all these various forms of criminal offenses should be integrated into a single treatment. And as a result of this amendment, the budget itself came into the focus of criminal law protection. And this has brought about a large number of various advantages. On the one hand, it eliminated unnecessary differentiation. On the other hand, it integrated value thresholds, and totally unnecessary cumulative problems have also been removed. The solution in the Hungarian Criminal Code belong to a category where the protection of the national budget and the EU budget is handled in an integrated manner. So it is the same facts that are to be considered. And the facts are defined in a sufficiently abstract manner, and this enables the country's legislation, Hungary's legislation, to meet the requirements of the European Union. And the legal consequences, the penalties, are also fully in line with the requirements of the EU. Moreover, the Hungarian legislation provides for stricter consequences. With this, I would like to thank you for your attention, and I wish to pass the floor to Madam Professor. Thank you very much. And as this is already the lunch break that I am using, I will make an attempt to very briefly summarize whatever I have to say against about our efforts against money laundering. So what are the reasons for us taking action? You have talked about estimations, and in this regard, we can only talk about estimations too. And some of the professional literature says that we cannot even talk about estimations. However, the International Monetary Fund and the World Bank argue that a significant part of the world's budget goes down with money laundering. And we have mainly analyzed, inspected, or examined the countries in the European Union, but we can also rely on information from other countries. And therefore, we can say that probably the amount affected by crime must be much bigger than what we have estimated so far. The protection of the financial interests of the EU's internal market and is what we have as our responsibility, and ultimately it is the protection of the financial interests of the EU citizens. So this is a supranational object of law, and this crime has a lot of international aspects because it is typically a cross-border crime. What are the means that we have available to us in our combating money laundering? I want to focus on the significance of preventive measures, and if you want to talk about criminology, then you should know that this is what featured first in the European Union. It was in the year 1991 when the first anti-money laundering directive was adopted, in which only the financial sector was involved under the scope of these preventive measures. The currently effective directive was adopted in 2015, and it regulates the means and tools available to us to combat money laundering that are outside the criminal code. This directive was amended later, and let me stress one aspect of preventive measures, which I believe was justified and necessary in order to prevent the actors from being overburdened with work, and this was the risk-based approach in the context of preventive measures, which means the service providers do not need to adopt measures to the same extent in every case, but depending on the risk that is involved, they can take lower level action. We can talk about public administration means as well, and the supervisory authorities have a mandate to impose sanctions. And Sándor Mádl, head of faculty, has already mentioned this. And the criminal cooperation between the member states is very important too. And we also have an operating analytical authority involved here, which is called the Financial Intelligence Unit, which are there in the EU member states that are receiving the criminal reports, and they launch they then call the regard of the various authorities to the suspicion of money laundering. And we must also mention the appearance of criminal law instruments, because before the Lisbon Treaty was adopted, the EU legislator did not have the opportunity to impose the necessity to indict actors in in money laundering. And it was in 2018 that this door was opened, and in fact it is to be considered as the first anti-money laundering directive, concerning which I wish to share a few thoughts with you. In terms of the legal foundations, it should be mentioned that money laundering is viewed as an EU crime, as a serious cross-border crime. This is how it is defined. The goal of the legislator with this directive was nothing less than to combat money laundering with the means of criminal law. And the investigative authorities were also intended to be supported by the introduction of these measures. The very structure of the directive reflects the same purpose. It identifies the notion, then it identifies the scope and the object. But I want to not only focus on the very facts of these cases, but I want to focus on the sanctions as well, because there are measures for sanctions in the directive too. And I also wish to call your regard to the fact that if the fundamental criminal offense is to be considered a crime, then it is the PIF, the PIF directive, that is to be applied in our efforts to combat money laundering, which means some problems in the course of the application of the law, especially in the case of a crime where the European prosecutor has a scope of authority. In terms of notions and terminology, the Punishable Act or the Foundation Act identifies the property and the cryptocurrencies also belong to the scope of objects in this respect. And I want to focus on the system of sanctions in the anti-money laundering directive. We have seen in the previous slide that even So not only natural persons, but legal persons are also the target. So the measures, the sanctions must be effective, proportionate, and deterrent. These are the three fundamental requirements. And I want to stress that intentional money laundering and money laundering of your own assets carry a prison sentence of at least 4 years, and aggravating circumstances include, and this sounds a bit strange because in Hungary we only talk about qualifying circumstances, but in some countries they speak about aggravating circumstances, so the EU is using the same term as well, and acting in an organized manner is an aggravating circumstance, as well as there is a certain list of offenders, and if you belong to one of them, then the sentence may be stricter. As it must also be mentioned that the amount of the funds that are subject of money laundering also represent an aggravating circumstance, but there is no indication within the directive as to what exactly it means, what the sum, the amount really is. And another interesting feature of the directive is that there are some crimes, and theft is not included here, where in view of the nature of the fundamental criminal offense, the legislator at the EU level thinks it is justified to impose a stricter legal consequence. Now, this is about the EU, but how about in Hungary? It is since 1994 that money laundering has been a punishable act in Hungary, and I think a total number of 10 amendments have been made, and the new criminal code, well, it cannot really be called a new thing if it has a past of 10 years, but the current criminal code uses a new solution. There is an independent chapter that regulates money laundering, and there is also an interpreting provision as part of it. And it's also of great significance, and many of the previous speakers yesterday and today mentioned the same thing. So I want to do the same. Mr. Csemegi, the Csemegi Code is an important code in Hungary. And we have some traditions concerning money laundering, because the reception of stolen goods used to be a form of money laundering in a way, and it is now treated in a different way as opposed to our traditions, and I believe it can be called into question, and as Mr. Bánati said, it raises certain problems. But I will not go into the details of the effective regulation. Instead, I will focus on a different area. It is to be observed in Central and Eastern European countries that the same trend was developing, namely that there is no effort to restrict money laundering acts to a restricted list. Instead, they are using a polycrime approach. So any crime can be classified as money laundering if the attitude is there. Negligent money laundering is one example, although the EU directive only makes a recommendation to the member states in this regard, but does not impose any mandatory requirement. And another interesting feature is that concerning the fundamental criminal offenses, there is a need to impose proportionate measures. So if the legal consequence of the fundamental act is lower than the legal consequence of money laundering, in some cases, in some countries, this lower legal consequence is applicable for money laundering as well. And I only have 2 more slides left. One is about Eurojust having issued their assessment concerning money laundering, and they summarized experiences in 10 points, and they identified that the fundamental criminal offenses have been identified in different ways in the various member states, and the evidencing procedure is also different in many countries, and there is an absence of criminalizing the laundering of your own assets. And I think there will be some progressive developments concerning cryptocurrencies if money laundering is committed with cryptocurrencies. So Eurojust has made some recommendations as to how to remedy the current shortcomings. And one more point about what we can expect within the European Union. In 2020, the Commission issued a communication, but in fact it is nothing short of an action plan. And it intends to strengthen the current EU framework, and there is a book of regulations, as it is called, in the area of combating money laundering. And they also argue that there is a need for a more efficient implementation of the current instruments. However, this book of rules will be not yet a separate criminal code at the level of the European Union. It is only preventive measures that are included there. However, there is an innovation in the anti-money laundering efforts, namely that it is possible to issue decrees, and there is no need for legal harmonization there because the EU's decrees will be directly effective in the member states. Thank you very much for your attention.